Hello friends, how are you? Today I am going to discuss an important topic concerning Prevention of Corruption Act. The accused has been acquitted under Section 7 and 13(1)(d) of the Prevention of Corruption Act, and we have to understand the basic analogy behind the scene. We have to consider the basic success story of the concerned accused, because after getting convicted, every person got depressed. So what will be the best method to fight the case under the Prevention of Corruption Act is going to be taught by this citation. In this case, the various parameters has been discussed. So we have to know each and everything, and we are having the same factual score. Then this citation would be very much beneficial to us to fight the case under the Prevention of Corruption Act. I will discuss each and everything without any concealment. I will discuss the basic facts, the basic argument, the observation, and finally the outcome of the court verdict, so that if you are having the issues on the same line, you could get the benefit from that citation. I am a defense counsel. My duty is to enlighten you about your rights. My belief is on the Constitution of India, which says that the right to life and liberty is quite important, and no one can take away the same. If everyone is going to take away the same, then they have to justify the process is due process. So the thing is that if you are a government servant, we ask about some money, we accept some money, it doesn't mean that we are a culprit. The prosecution has to show that we are having the official power, we want to abuse the official position, we enter in a position to accord a satisfactory official benefit to the concerned complainant, and in lieu of which he offered certain money or we demanded certain money, that is a bribe amount. So the topic is important. Please note down the same, and in future if you are having the same problem, or in present you are having the same problem, this video will be beneficial for you. Okay now, so let's start the topic. But before starting the same, I want to clarify that the various linguistic version of this video is available. You may listen this video in Hindi from North India, in Punjabi if you are from Punjab zone, and right now this video is recorded in English for the South Indian people and for every person who understood English. So let's start topic, and be patient and note down what I am going to narrate to you, so that you could work out in a very better way on your case. Friends, the judgment is passed by Honorable Madras High Court. It is passed on 11th of April 2023. The basic facts are that in that case the accused has been convicted under the Prevention of Corruption Act, and specifically the offence was under Section 7, 13(1)(d), 13(2) of the Prevention of Corruption Act. You got the point? I think that you have noted down the same. Easier now? Now we are coming on the next chapter, the facts of the case. The prosecution case is that the appellant, while working as a public servant and while discharging his duty as a public servant, with additional charge demanded a sum of rupees 1,500 as a bribe. For what purpose? To process the application of de facto complainant for getting benefits under a particular scheme. The de facto complainant declined for the bribe, and ultimately he submitted the report to the Inspector Vigilance and Anti-Corruption. Soon after that, verification was done, trap was arranged, and finally when the appellant came to State Bank of India, that is very important, she was caught red-handed with the bribe amount. So in number of cases under the Prevention of Corruption Act, these following facts usually occur: that the accused demanded, and at a particular place he had come, where the concerned complainant met him or her, and inter alia he took the alleged amount which is demanded by him or her previously. Basic facts of the case are same in number of cases, but the key point is that the de facto complainant died before the trial, the plus point for the accused. To prove the charge, they have examined the witnesses, exhibited the documents, and as per testimony of the prosecution witnesses involving the investigating authority, which is corroborated by the evidence of shadow witness, that on a particular date the concerned person means the complainant, registered his wife's name for getting treatment during the gestation period, and also the benefit extended by the government for pregnant women who are living below the poverty line. He submitted document before the accused herein during the month of September, and for a long time his application was not processed. That was a basic allegation. Since he approached to the concerned appellant accused, she informed that his application will be processed soon, and subsequently when he met, she demanded a sum of rupees 2,000 to process the application. So the first demand on 22nd of December is of rupees 2,000. Please note down it. The initial demand is of 2,000 and it is made on 24th of December 2014. Next day he went and negotiated. That is very important. It is scaling, and scaling is not permissible because it inter alia casts a doubt on the genuineness of the prosecution, and apart from that, it makes the entire case suspicious, as observed by Honorable Supreme Court in number of cases, from 2000 to 1500, and finally on the next day he was asked to come with the money. The de facto complainant pledged his jewels and raised fund of rupees 2000. It also raised a doubt. Why? Because when the demand is of 1500, then why he raised the fund of rupees 2000 and gave it to the concerned vigilance inspector? Subsequent to this, the trap proceeding has been initiated, the witnesses has been called, and they are recognized as shadow witness for the trap proceeding. And ultimately, phenolphthalein sodium carbonate test demonstrated in the pre-trap proceeding. The consent documents has been prepared, and finally de facto complainant on 24th of December 2014, between particular period of time, tried his best to make successful the trap proceeding. In the meanwhile, the de facto complainant called the accused over cell phone and informed her that he has come with money. As per instruction, de facto complainant and shadow witness were waiting near the State Bank of India. Another trap team took their position. That is very important. It means the consent complainant and the shadow witness are the eyewitness, and remaining are the hearsay evidences. The key point is that the accused came in an auto. The de facto complainant went to her and gave her the tented amount, that is rupees 1500. The accused received the amount and kept the money under her lap. That is a basic point. The trap team rushed to the auto, caught the accused, tented money was recovered, the test was conducted, it was found positive, and ultimately in the presence of independent witnesses, the money has been recovered and the house of the accused was searched and certain incriminating articles has been recovered. Subsequent to this, the trial court, relying upon the evidences of the shadow witness, has held that demand as well as acceptance is proved, and the witness PW3 also corroborated the evidences of other witnesses, and that's why it is a fit case where accused deserves to be convicted, because demand and acceptance is duly proved, and even though the complainant is not examined due to his death, in that scenario it will not adversely affect the case of prosecution. Finally, the accused filed an appeal before the Honorable High Court as per the protocol of section 374 of CRPC. Please note down the same. The learned counsel appearing for the appellant submitted that the prosecution failed to prove the demand and acceptance. So basic attack is on demand and acceptance by the defense. And apart from that, he submitted that it is a basic requirement to be proved for the offences under section 7 and 13(1)(d) of the Prevention of Corruption Act. So these are the basic points on the record. He submitted that the complainant is died and only eyewitness as per the prosecution for demand and acceptance is PW2, and remaining are the hearsay evidences. Even though the testimony of PW2 is accepted in toto without any cross-examination, the acceptance of money is proved but demand is not proved, and the law says that both points should be proved simultaneously. He submitted that as per the testimony of PW2, the auto in which the accused came stopped around 50 to 60 feet away from the place where he and de facto complainant were standing. The de facto complainant ran towards the auto and gave the money to the accused. The witness PW2 followed the de facto complainant 5 to 6 feet away, but at that time PW2 could reach the auto and de facto complainant already given the money and returned back. So it indicates that he is not the eyewitness, even though he is a hearsay witness, because he had not observed, even seen, even witnessed the alleged transaction. And apart from that, there is no evidence to prove that the accused received the tented amount as bribe, and that was offered by de facto complainant pursuant to demand made by the accused. And apart from that, the accused has given the plausible explanation after recovery. And note down that this explanation is to be given as per rule number 47 of CBC guidelines, and which is sufficient to rebut the presumption, because the Supreme Court says that it is not necessary the accused should prove the defense beyond doubt or he has to come in the witness box. He could rebut the presumption by preponderance of probability, and by doing the same he is required to do the elaborate cross-examination, and that is sufficient test for doing the same. So in that scenario, he submitted that the foundational fact of demand is not proved. That's why no presumption under section 20 could be drawn. That is very important. He submitted that the case of prosecution is that the de facto complainant and accused were in contact through their cell phones, and their cell phone numbers is also mentioned in the FIR itself. It is also averted that soon before the trap, the de facto complainant called the accused, and on a request he reached along with shadow witness near the State Bank of India, but the call details of de facto complainant and accused were not collected by the investigating authority. So it is a major lacuna in the case. The connecting evidence is totally missing on that point. Apart from that, the testimony of concerned PW4 is also unreliable because in his statement he made contradictory statement. So he submitted that the case is not made out. Apart from that, he submitted that the application form of the de facto complainant for his wife also was not fully filled up. Except the signature of the beneficiary, no information was found. He submitted that the accused was on medical leave for a particular date for the treatment of her fractured leg, and only on the date of trap she joined the duties. So therefore, there is no occasion that she demanded and accepted the alleged amount voluntarily, knowingly that the same is a bribe amount. And apart from that, there is no evidence on the record which could connect the accused with the crime. The state has opposed the contention, and as per the state, everything is proved. So judgment is totally reasonable, and there is no scope for the interference. And apart from that, the concerned APB requested to reject the appeal with cost. The court observed, after hearing both the parties, that the concerned trial court has laid undue reliance on the testimony of PW2, who supposes to be the eyewitness, but in fact he is not the eyewitness, because when he has reached, the transition has been taken place. So the concerned eyewitness totally goes out of picture. The eyewitness died already because the complainant was the only eyewitness. And apart from that, there is no one who has allegedly witnessed the alleged transaction, and they are hearsay. And as per section 59 and section 60 of Indian Evidence Act, the testimony of hearsay evidence is not relevant. And apart from that, the telephonic conversation and the material evidence are not put on the record. The foundational facts are missing. So in that scenario, the prosecution totally failed to prove in which manner the accused is liable, in which manner the tainted money recovered from him entirely comes with the purview of the consent bribe. When the linking evidence are missing, the correlating evidence are missing, the coagent evidence are missing, the demand is not specific, there is a scaling and other circumstances not corroborating the case of prosecution. In that scenario, the accused could not be convicted. In that scenario, the court found that the prosecution totally failed to prove the foundational fact. If foundational facts are not proved, in that scenario, the presumption could not be drawn and sentence passed by the concerned trial court is liable to be set aside. So friend, in this case, the accused has been acquitted from all the charges. So basic three things we could understand. Number one, the prosecution is required to prove the case beyond doubt. If it proves, then only the presumption will be drawn. Number one. Number two, the accused is required to give the plausible explanation as per the protocol of Honorable Supreme Court. He is or she is not required to prove the defense beyond reasonable doubt. Number three, the concerned prosecution, if fails to prove the demand, even though there is acceptance, recovery of money and other parameter, even though he came to the spot, he means the accused, the concerned prosecution could not say that he is having the ill intention or bad intention for which he has come on the spot for the money while fighting the case under the Prevention of Corruption Act. So this is an important topic. If it enlightens you, please share this video, subscribe my page. See you in the next video. Till then, Jai Hind, Jai Bharat.